In the pre-dawn darkness of colonial Boston, a printer arranges metal type by candlelight. Each letter is a small, heavy thing, backward, precise, real. His hands know the work, selecting from the case, setting words into the composing stick, locking them into the frame. When morning comes, the press will turn and ink will transfer these words onto paper. Once printed, they cannot be unprinted. They become permanent. They become dangerous. This is why his work mattered, and this is why, a generation later, the framers of the Constitution made the printing press's safety their explicit concern. The First Amendment reads, "Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances." 5 distinct protections sit inside that sentence. They are not one protection stated 5 ways. They are 5 different freedoms, each born from a specific historical wound. Begin with speech. The word is broad by design. In 1791, it meant the spoken word. Over the centuries, courts have extended it to cover symbolic actions, financial contributions to campaigns, expressive clothing, nearly any communicative act directed at an idea. But the amendment protects speech from one actor only, the government. It does not protect a person from their employer's response, their community's judgment, or the consequences of their words in the marketplace. It does not insulate speech from social cost. It prevents the government from making laws that silence it. Religion occupies a strange position. 2 clauses work in opposite directions. The Establishment Clause prevents Congress from favoring any religion or creating an official one. The Free Exercise Clause prevents Congress from burdening the practice of religion. These 2 clauses exist in tension. In the colonial period, many states had official churches, funded by tax, taught in schools, embedded in law. The framers, having witnessed the damage of state-sponsored religion, rejected that model entirely. They chose neither establishment nor prohibition. The system aims for government neutrality, no favor, no interference. The press was a technology. It was the printing press, a specific, material thing that could disseminate words beyond the reach of a single speaker's voice. Seditious libel laws in England had criminalized printed words critical of the government. Colonial printers knew this risk. When the amendment names the press, it names the instrument that made that risk possible and the tool that democracy would need. The principle has extended to other media, newspapers, broadcast, digital platforms, but the original concern was literal: ink on paper, multiplied and distributed. Assembly is the gathering of bodies. People marching, people meeting, people organizing in the street. The colonial government had suppressed such gatherings. The framers protected the right to assemble peaceably, but not absolutely. Time, place, and manner restrictions remain constitutional. A parade may require a permit. A gathering may be limited to certain hours. The right itself is protected. The regulation of logistics is not. Petition is the most formal of the 5. It is the written or spoken request directed at government for change. It assumes that citizens have a channel to reach power and ask for redress of grievance. Modern equivalents include comment periods on proposed rules, testimony before legislative committees, and formal complaint procedures. This freedom often passes unnamed and unremarked, yet it remains functional, a constitutional guarantee that power must listen, even if it need not agree. What the amendment does not say matters as much as what it does. It does not protect speech from all consequences. It does not prevent private censorship. It does not address defamation, fraud, or direct incitement to imminent lawless action. Those domains belong to other laws and amendments. The boundary between protected speech and unprotected speech has been drawn and redrawn through centuries of court cases, each one testing the words against new circumstances the framers could not have imagined. The text itself has remained unchanged since 1791, but its application has shifted. What counts as speech has expanded. What counts as religious exercise has been redefined. What platforms must do to host assembly and petition has become a new question. The 5 freedoms named in that single sentence continue to be deliberated, tested, and refined. The printer's broadside distributed at dawn in Boston was one small exercise of these protections. The system that made that act safe, and the argument that has continued ever since about what safety means, that is the First Amendment's real life.